Rent arrears, one of the most common problems that landlords may face when letting out their property. Here, we'll be looking at the eviction process based on unpaid rent in relation to property that's let on an assured short-hold tenancy agreement. The eviction process is a three-step process, and before commencing that action, the landlord or the landlord's agent should make all reasonable attempts to communicate with the tenant to try and resolve the rent arrears if possible. Unfortunately, in many cases, the rent arrears are not resolved despite the landlord or the landlord's agent's efforts. And in that eventuality, the landlord has no alternative but to start legal action. If legal action does need to start, the first step for the landlord is to serve the tenant with a Section 8 notice, also known as a notice seeking possession or Form 3. The Section 8 notice is a prescribed document, and that means it's prescribed by law. Therefore, you must ensure that you're using the up-to-date version of the Section 8 notice. Where a Section 8 notice is served based on grounds of unpaid rent, the minimum notice period that must be given to the tenant is 14 days notice before court action can commence. But more than 14 days notice can be given. And it's also important to note the Section 8 notice is valid for a total of 12 months. So court action must commence within those 12 months, otherwise a new notice would have to be served before commencing court action. Once the notice period has lapsed, and if the tenant remains in possession of the property and the rent arrears have not been cleared, the landlord can now issue a claim for possession to seek a possession order based on the grounds of unpaid rent stated in the Section 8 notice, and the court can also be asked to make other ancillary orders, such as a county court judgment against the tenant, and if there's a guarantor, they can also be added to the claim to seek a county court judgment against the guarantor. The court can also be asked to release the tenancy deposit from the scheme, and that order is needed because it's quite unlikely the deposit scheme would release the deposit to the landlord to cover rent arrears. Therefore, the court do have the power to order the deposit to be released to the landlord, and that order can then be given to the deposit scheme so that they can release that deposit to the landlord. Now, of course, the county court judgment for the unpaid rent will only be for the unpaid rent up to the date of the court hearing. And that's why the court is often asked to make an order that the tenant pays a daily rate of rent from the next rent due date from the court hearing until they give up vacant possession of the property. And that way the landlord is claiming for every penny of rent that's due up until the date that the tenant is evicted. Now, once a possession order has been made, the tenant is often given 14 days by the court to leave the property. If the tenant has pleaded that they would suffer from exceptional hardship and the court is satisfied that they would suffer exceptional hardship, the court has the power to give the tenant up to 42 days, and that's the maximum the court can give before having to leave the property. Now, whatever period the court has given the tenant to leave the property, once that period has passed, and if the tenants are still in possession of the property, the next step for the landlord, which is the final step in the eviction process, is to issue a warrant for possession for the county court bailiff to carry out the eviction of the tenants, to enforce the possession order. If the landlord has permission to use High Court enforcement, then the landlord could instead issue a writ for possession for the High Court enforcement officer to carry out the eviction. High Court enforcement is quite expensive in comparison to county court enforcement, but it's often substantially quicker than county court enforcement. So that is, in a very brief form, the three-step eviction process based on unpaid rent. We have in other videos covered step 1, step 2 and step 3 of that process in a lot more detail. If you have any questions about the eviction process, or if you'd like us to handle that for you, then you can contact Landlord Advice UK's legal team and we will be able to assist you through that process.